Blood Money. Article by Anna von Reitz, Part 15. Additional issues for the International Court of Justice. Our employees. Our particular kind of government allows for one state assembly in each state of the Union. This is the sovereign and unincorporated state in each case. Together these states, by custom and for their mutual self-interest, delegate certain of their international and global powers to the United States of America. Both the United States and the United States of America being referenced are unincorporated entities employed as instrumentalities by the 50 sovereign states of the Union. As of the 1st of October 2020, the pre-Civil War state assemblies voted unanimously to enroll the Western territorial states, created under the Northwest Ordinance since 1860, and chosen to make enrollment effective with the date and time that these states entered territorial statehood. All 50 states of the Union are populated. All 50 state assemblies are in session, and all members of these assemblies are properly declared and publicly recorded birthright Americans. All 50 are fully empowered, enrolled, and endowed with equal powers. Our state assemblies are lawful, unincorporated, and have standing as sovereign states under national, international, and global law. Our paid federal employees, who are by definition district persons, have been running around behind us trying to put together district assemblies populated by district personnel, because they are struggling under the misapprehension that we need Confederate states, that is, state of states, to function in international trade and global commerce. This is not the case. The incapacity of the Confederation and the incapacity of the Federal Republic are both moot issues in the face of the actual Federation of States. Our unincorporated Federation of States, the United States of America, which is the source of all the delegated powers in international and global jurisdictions, is completely competent to function in both international trade and global commerce without any representation or grant of agency. Indeed, our Federation did exactly that for a period of 5 years and has the option of doing so now, and has availed itself of that option. Both the territorial United States and the municipal United States must stand down and cease and desist from all efforts to impersonate us, to interject themselves as our agents, or to otherwise pretend to be us or represent us apart from their clearly enumerated constitutional obligations. The principals responsible for these organizations are required by treaty and commercial contract to cease and desist attempts to latch our assets, traffic our assets, securitize our assets, or in any other way pretend authorities never vouchsafed to them. The Pope, the Queen, and the Lord Mayor, together with their respective governments, have no authority or occasion to impersonate us, substitute themselves and their citizenry for us, or to conduct business for us, as we are present and accounted for and taking care of our own affairs. We have served public notice and due process of these facts to these principals and throughout the international community, and we are addressing the International Court of Justice, Vatican Chancery Court, and the Court of the Lord High Steward in affirmation of these truths. No man and no nation should be deceived further by any semantic deceit seeking to misrepresent the United States of America as an incorporated entity, nor seeking to impersonate our states of the Union as state trusts, nor otherwise attempting to pass off foreign persons as Americans and pretending that their foreign district assemblies are in any way required to exist for any emergency purpose, nor pretend that district assemblies are competent to replace the actual state assemblies. In all cases, circumstances, and jurisdictions, our state assemblies are the only sovereign governmental entities on this continent. Any other kind of assembly composed of foreign persons is self-evidently posturing upon our strictly limited delegated authorities and trying to assume the powers of our state assemblies without any vested authority to do so. In fact, the existence of district assemblies on our soil was never contractually agreed to, and their operations have caused a considerable amount of disruption, fraud, and confusion. These assemblies of foreign persons on our shores have indiscriminately welcomed non-federal employees and conscripted our people without full disclosure, as well as latching upon our given names, and presuming against our self-evident nationality via unconscionable registration processes and adhesion contracts, all of which we disallow. We wish it to be universally known and fully acknowledged that the Americans are home, and in truth the vast proportion of us never left. Any pretensions by our federal government subcontractors or their incorporated instrumentalities otherwise must be recognized as self-interested prevarication amounting to constructive fraud and purposeful deceit being pursued in the cause of unjust enrichment. The sum total of any powers ever delegated to any of our federal subcontractors or secondarily entrusted by them against their honor to agency personnel are matters of public record established more than 200 years ago. No, we have not all adopted any form of federal citizenship. No, we have not agreed to employment or dependency. No, we have not agreed to enfranchisement. No, we have not recognized any emergency powers. No, we have not vacated our government. No, we have not yielded any legislative power to our paid employees and their dependents, except for those legislative powers allowed within the District of Columbia as already discussed. Anna Maria Reisinger, Fiduciary, the United States of America.